Good morning, everyone. Welcome. It's good to see you all on this. It's snowing actually right now, snowy Thursday morning. It's snowing here at least. We're just give everybody a minute or two to get in, and then we'll go ahead and kick things off. Um, so good to see everyone. My name is Ellie Burns. I'm the Senior Director of Nonprofit Relations here at the Community Foundation, and really excited to welcome back our friend and colleague, Sarah Ogborn from Connectify, just to follow up on a conversation that we sort of kicked off in right before July, talking about sort of the impact of the FLSA overtime rule decision. And so, some things have changed, and we just wanted to invite Sarah back to give us kind of an update. So Sarah has spent the 20 years of her professional career supporting employees and clients in creating and maintaining positive, productive, and engaging workplace. Currently, Sarah collaborates with clients on strategic HR initiatives to help them achieve their organizational and people-related objectives. Prior to joining Connectify, Sarah worked in HR and training for Hy-Vee, both at the operations and corporate levels. She holds a master's from Drake in adult learning and organizational performance, a bachelor's in communications from Iowa State, and is an SHRM, senior certified HR professional. So she's wealth of knowledge. We always love bringing her into chat. So we're excited to turn it over to her. Just a few housekeeping before I do that. If it's a small group today, so if you have questions, please just feel free to unmute and pop in with them or throw them in the chat and I'll monitor that. We are recording this, so if afterwards there's information that you think would be helpful for your colleagues or your board, you'll get the recording and you're more than welcome to share that out. So, okay, I'll stop talking and let you take it from here, Sarah. Thank you.
Great, thank you. And do you have slide presentation? Or do you want me
Sarah's
to share?
manning that. So if you just say next slide, she'll,
Perfect.
yep, great.
Perfect. Thank you so much. Thank you so much. And Ellie, thank you so much for that wonderful introduction. It's really, really good to be here with you all this morning. I know a few of you I work with on a fairly regular basis, so great to see some familiar names and new names to me here as well. Ellie and I were just kind of chatting a little bit before you all came online that, this is, I think, the better and maybe quote unquote easier part of this conversation, just by some of the things that have come down the pipeline recently. But again, we want to fill you in. We want to make sure that you have ample information in which to act on should you need to. Maybe some of these updates, because this is new information, but it's not necessarily hot off the press. This is about a month old. So you may have an idea of kind of what's going on and what the implications are for your organization. But I do think it's great to just, again, review really what's happening, kind of the why behind it, do a little bit of a forward look and plan, right, at any sort of actions or communications that may need to be taken. So that's really the purpose of today, is just to go over these latest developments, that district court ruling, which again, I think is most people will look at as a favorable thing to happen in the employment landscape, and really just kind of some suggestions in terms of how to work that and how to break that information down. And if you were here with the last meeting on this topic that my colleague Kelly Gottner facilitated, we're going to kind of use that as a springboard to look at this information and facilitate it from that specific perspective and some of the action steps and items that she gave too. So hopefully that will help connect the dots, if you will, on some of that as well. So you can go ahead and flip to the next slide. So, where were we? And again, this is an exact slide that we pulled from the presentation that was done prior, right? So we had these regulations that were coming down the pipeline in terms of the July 1 increase, right? Where we had to make the change on this exempt level salary threshold from the 684 that we had been accustomed to for a while, up to that 844 per week threshold, or 43,888 annually for exempt employees. And then if you had highly comped employees in that category, up to that 132,964. Okay. So that was kind of the big news at that time, right? Is how do we deal with this July 1 increase? That's pretty significant in nature, frankly. And then, oh, by the way, we've got this January 1 thing sort of looming over us potentially, that's going to take that increase and make it even more vast, right? So the 1128 per week, almost 60,000 a year, which I know because I partner with a lot of nonprofit organizations, is very, very impactful. And we have people kind of wringing their hands. Oh my gosh, maybe we can do the July 1, but what's going to happen in January, right? And how are we going to deal with that? And then, oh, by the way, not only are we putting those things in place, but we're going to put this escalator in there every 3 years. And maybe that's helpful, right, to kind of mitigate some of these big increases that we're seeing. But that was kind of part and parcel of what was coming down the pipeline as well. And then lastly, and this is kind of true of almost anything in the employment law landscape, if the state that you operate in sets a higher standard, right, that always is going to sort of trump federal law, which is not different in this particular case, right? So I know we have a lot of people who probably firmly operate in Iowa, but if you were in a state where that salary threshold was more elevated than what the federal standard was, you would certainly, follow that because you would be in line with federal then as well. So flip to the next slide and we're going to kind of see, so what's the impact of this November 15th decision? Here we go, right? I mean, it's basically taking all of those things that were in place and saying, strike that down for now, right? And we're going to see a slide in terms of kind of the why and how behind that decision here on the next one. But again, it's essentially taking all those increases that were in place, even the July 1, right? And we're kind of saying what's old is now new again. So you can revert back to the 684. If you want to, that 844 is no longer standing. We're not doing the 1128 per week or the almost 60,000 per year that was set for January 1. That's no longer happening. And this every 3-year escalator is not happening either. So the court has basically struck that down, at least for the time being. So again, I think for most employers, right, breathing a sigh of relief that we don't necessarily have to make, especially for January 1, that really, really tough decision in terms of what we're going to do. Again, still stands where if the state does have a higher standard, because that will happen from time to time, that you should follow that. And then obviously that would very much put you in line with the federal standard as well. So go ahead and flip over to the next slide. So really, how did we get here? How did we get to, basically we're scrapping everything that we knew to be true or that was coming down the pipeline. So in mid-November, and again, you've likely seen at least, a piece of news come across your computer screens likely. The U.S. District Court for the Eastern District of Texas vacated the U.S. Department of Labor, the DOL's final regulation increasing the salary threshold for those white collar exemptions under the FLSA. But even though it's a district court in Texas, it's got nationwide reach, right? So this impacts all employers across the nation. Again, striking down that increase of 58,656 that was set to go into effect on January 1. And then also saying, listen, the July 1 increase is now off the table as well, which we talked about. And basically what the court is saying is, listen, DOL, you have way overstepped your authority here. You've basically put a wage threshold in place that's so high and so unreasonable, it negates the duties tests, right? Because if you think about this exemption, right, you have to meet the duties tests and criteria plus the salary basis test, plus the salary level test. And they're saying that level has just literally been set too high that it's negating the duties test. And frankly, that's just not acceptable to us. And it impacts so many employers. The projection was that it was going to impact, all employers nearly, but 30% of exempt employees nationwide it was going to impact. And that's just millions upon millions of people. And they're saying, no. That, the overreach has gone too far and we're gonna roll that back, at least for the time being. And again, the court also struck down the automatic increase in the salary threshold every 3 years that was originally in place. So again, that's kind of the big news headline, right? Is that all of these things have been rolled back a little bit in relationship to this November 15th ruling by that district court. So if you want to advance to the next slide. So really, what do we do? What do we do now? Because this isn't necessarily a closed case still. It's like kind of kicking the proverbial can down the road. So again, there could be appeal. There could be appeal to this particular ruling, but likely there's going to be no action taken right before President-elect Trump takes office. So we do think that there is going to be some stability here for the time being. So when Trump does get into office, there's a couple of ways that this could go. They could formally repeal that final overtime rule that was set by the DOL under the Biden administration, or they could choose to revisit and just revise or revamp pieces and parts of it. So again, it's just a little bit hard to say. It's still a little bit open-ended. And so again, much like anything, we're going to keep our eye on it. Who knows? Maybe we'll be back here in another 6 months talking about more changes that are coming down the pipeline. But again, we anticipate this to be relatively stable for the time being anyway. So, contextually, then the next step is to think about, what action did you take as the employer as a part of that July 1 increase, right? Or, were you planning to take action or had taken action or had communicated something in anticipation of this, January 1 increase, right? So what I want to do next is look at the options that were presented before and really kind of talk about, if you did this to be in compliance at the time, what are the options now? So let's go ahead and flip over to the next slide. So the first scenario in relationship to the July 1, so we're very much talking about that, was that you could increase the salary to $844 per week to comply with that 7-1 threshold, right? What do you do now? So that's been rolled back. You no longer have to meet that 844 threshold. You can simply stay course, right? So you can simply stay course if you raise people to that threshold and you want to just keep on business as usual. That is absolutely 100% an option. There's no requirement, certainly, that you roll salaries back, right? That almost sounds a little silly even saying it. However, you could reduce salary on a go forward. But certainly, I think we've got folks on this call, right? You understand, for morale reasons, that would be pretty devastating to your employee population and your organization, right? Hey, this, new ruling just came out and we're actually going to give you a pay cut now in relationship to that. Like, that's just not a great message to deliver. And I personally would not advise my clients to proceed forward in that manner. So again, you just have to read your own mail on that, but you can reduce the salary. Like, that would not be out of line in relationship to the actual law or regulations itself. The thing that you can't do is make a retroactive adjustment. Hey, we're going to cut your pay. And oh, by the way, we're going to actually collect the overpayment that we've been paying you for the last 6 months. Again, that almost just sounds silly to do, but the law does specifically prohibit that. So you could reduce a salary on a go forward. You cannot do it retroactive from an adjustment perspective. So do just be aware of that. And then I would just say, carefully consider if you want to roll back any plans that have either been made or communicated due to the now defunct January 1 increase, right? So have you communicated an increase? Have you communicated a change in exemption status that was slated to happen January 1 in light of? I can tell you, my hope is that maybe you held off, right? Because this was in such a state of flux that you don't have to walk anything back. But if you did communicate that an adjustment in some form or fashion was coming down the pipe as of January 1, you may have to consider, again, am I going to stay course with what I planned to do? Or am I going to walk that back in some way without damaging, again, morale, depending on what the messaging was to the employee in terms of the action that was going to be taken on January 1, perhaps. So again, that was, some of the considerations if you did make that bump in salary for the 7/1/24 threshold. If you want to flip to the next slide, the other thing that you could have done on July 1 to accommodate was converted your position. So maybe bumping up to the 844 was not feasible for you from a fiscal standpoint, right? And so you were going to take somebody and make their position non-exempt. You were going to make that conversion. So if you did that, here's kind of the slate of options that I would lay out for you now. First thing that you can do is change the position classification back to exempt. Okay. Few things that I would want you to consider if doing that. So ensure the salary threshold is at least 35,568 or that's 684, which was customary prior to July 1. The biggest thing that I would also not want you to overlook here is making sure that those duties tests are met. So again, typically we're talking about executive, administrative, professional, learned professional exemptions, right, in the sphere that you all are working in. Don't forget about the duties tests, right? It's not just meeting the salary threshold, it's making sure that those duties tests are satisfied as well. So do just keep that in mind as you're thinking about rolling something back, potentially to an exempt classification, especially if you reassign some duties in that process that would have taken some of that discretion, independent judgment, or exempt level duties off of that person's plate. That would be something that you would want to take highly into consideration. I would also say, consider overtime, right? So if you transitioned somebody to non-exempt and then they had the opportunity to start working overtime hours, and they're now become accustomed to that over the last 5 or 6 months, would rolling them back into an exempt level position where they don't have the opportunity for overtime be almost like an inadvertent wage reduction. So again, just think about that too as you're analyzing path forward there. That would be something to take into consideration. Certainly you would want to craft a communication plan and operate in transparency. I've worked with a few clients that have made the decision to change the status back. So we've deployed an FLSA status change notification letter, which again is just a great high level document to say, this is what's happening to your status and why. This is what it means for you from a salary and timekeeping perspective. And this is how we move forward. Let me know if you have any questions. So it's not a terribly complex document, but it is a nice piece of paper to get everybody on the same page. So again, if you would be interested in seeing a template or something of that nature, let me know. I would be happy to provide that in conjunction with this presentation. And then I would just say, analyze the appetite and capacity for more transition. If you were to decide, if you made your employee, you took them from exempt to non-exempt, and then you're going to take them back to exempt again, that feels a little bit just like a seesaw, right? So maybe they've settled into their non-exempt status. It's okay. Everybody's operating at status quo and the waters have calmed. Is it worth introducing additional change or transition back in? So again, I don't know the right or wrong answer. I think you have to evaluate your own personal circumstance, but that is something that I would just evaluate as you're thinking about a potential change back to an exempt status if you did convert them to like an hourly non-exempt person come July 1. Okay. On the flip side of that coin, again, you can stay course with your non-exempt position classification. What I always tell folks and employers is non-exempt is always going to be your default status of any sort of a position, right? There is no legal risk to you for maintaining a non-exempt classification. So what I mean by that is, again, you could always have somebody non-exempt. Extreme example, CEO of a company, right? They can be non-exempt. You are not required ever to make a position exempt. When you do that, that's where you have to meet those very specific criteria set out by the DOL. So again, there's never going to be any risk in maintaining somebody's non-exempt classification. And why is that? Because it's more, the DOL is going to look at that as more favorable to the employee, right? They have the opportunity to earn overtime if they work over 40 hours in a week, as in their quote unquote, not getting taken advantage of by their employer. Okay. I would also say, kind of like, the last bullet point on the left-hand side, gauge your employee sentiment. Were they happy to have the opportunity to earn OT? Were they happy to have a perceived better work-life blend? Maybe they're like, listen, I can actually come home and feel like I can check my work at the door and I don't feel obligated to check email. I don't feel like I'm obligated to do something at night or on the weekend. And maybe that was a sigh of relief for them and they kind of like where they're at now. Again, do you want to muddy those waters if they've seen that as a positive change for their particular circumstance? So I think that's up to all of you as individuals to gauge, where do your employees stand on that particular matter? And then another thing I would say here, again, kind of converse to what we saw on the other side, is just analyze your ongoing overtime liability, timekeeping and logistical considerations, right? So if you are all of a sudden, because of the non-exempt transition, having an abundance of OT, right? That's an expense. That is a very real thing that you need to gauge. So if that is not palatable for the organization going forward, again, if they meet the duties and the salary criteria thresholds, again, a change to exempt might be advantageous from an organizational perspective. So again, there's lots of things to kind of consider as you're thinking about what to do in the context of where you are personally in terms of how you kind of steered course with this 7-1 transition. So go ahead and flip to the next slide, please. There we go. So just last minute things. And again, I think these are all implied, from the conversation that we've had thus far. I would just say, again, take stock of what you did for July 1. What pathway did you go down? And or, what have you done preemptively in preparation, again, for this now defunct January 1 situation? Vet the considerations for staying course or making changes. So again, utilize those last couple of slides to kind of say, okay, here's the things that we should be talking about and taking into consideration when determining how to chart a path forward. Again, determine any necessary communication and the timing as of those communications. I would say, if you've not done that, you're going to want to get on your horse and ride pretty hard, right? Because again, we're rolling downhill to the first of the year very, very quickly, especially if you're going to make a change to somebody's wage. We typically in Iowa, especially if you're going to do a reduction, have to give a person at least a pay period's notice. Plus, it's just good form anyway, right? Prepare that communication plan. And then determine when you're going to deploy those communications. And I would just say stay informed, which again, you've got the foundation that helps put on, informational sessions like these to help keep pulse on these things. Obviously, Connectify HR will continue to keep pulse on this as well for any kind of changes coming down the pipeline from the Trump administration. Again, whether it's completely thrown out and struck down or whether it's tweaked in some form or fashion. And again, we have to revisit this yet again. So we'll continue to keep pulse, and we would definitely invite you all to do that as well. So with that, I will pause and see if there are any questions, concerns, anything that I didn't touch on that maybe you would want addressed.
Hey, Sarah, I did have one question as you were talking. You referenced the duties test. Do you have a reference or some sort of a handout or anything that we could share afterwards that might give people more insight into what that is?
Yeah, absolutely. So I will send links to the DOL fact pages for those, Ellie, and then I might even send almost a modified version of those slides that I did for your guys's group.
Oh, yeah.
With the breakdowns, like those are very high level in companion with the links. And then I think that would probably get folks exactly what they need from a duties perspective. Yeah, that's wonderful.
Okay, thank you.
Of course. Anything else? All righty. Well, if again, you have a very specific organizational question, reach out to Ellie. If you don't have my contact information, please do feel free to reach out. I would be happy to chat offline too, if it is something that is very specific to your circumstance. And again, just want to thank you all for your time, and Ellie for the opportunity.
Thank you, Sarah. That was great. We appreciate the update and the thoughtfulness with which you kind of explained how you can go about, either making changes or whatever it is that you need to do. So thank you. Yep, follow up if you have any questions. As always, the Community Foundation has a variety of other resources available, from Give DSM, which if you don't have a platform on there right now, we would highly recommend it, as they were at the end of the year in giving season. Any upcoming opportunities, you can always keep an eye on our events page. If you don't get our nonprofit newsletter, please consider signing up. It's got some great information that comes out every month. And then don't forget, as you're planning for 2025, we have rental space available at the C3 Center. So thanks, everybody. We'll hang out for just a minute in case there are any follow-up questions. Otherwise, have a great afternoon and take care.